Am I live now? All right, good afternoon, everyone. So one moment, we're making sure we're live. Okay, it appears that we are. Good afternoon, everyone. Thank you for joining us today. Today is Friday, April 12th, 2024. This is the Lunch and Learn series with the Navajo Nation Department of Justice. Today, we're going to be going over the introduction to the Major Crimes Unit. Before we get into today's presentation topic, the Major Crimes Unit, I want to discuss some preliminary matters. First, this presentation will involve discussion of heavy topics. One, including murder, rape, sexual abuse and assault of Navajo children, violent and harmful physical assaults, and other aspects that we as Navajo people generally consider unpleasant to talk about. Generally, our people consider death an improper subject to talk about, and that's true. But sometimes death is a necessary subject to talk about, but still not one that should be gratuitously discussed. So, with that said, I encourage those of you who do not wish to hear any more discussion of these and similar topics to consider whether you wish to listen to more of the presentation. First and foremost, you should consider your own well-being and in being able to hear these discussions. Second, another disclaimer, while I will be responding to questions and comments after the conclusion of my main presentation, I cannot and will not be able to discuss specific cases. Those of you who wish to make comments on Facebook should avoid specific cases and using this Facebook live stream as an opportunity to report crimes and expect a response. This is not the appropriate forum to report allegations of criminal conduct. Third, and finally, generally we, the Navajo people, prefer not to use the word Indian because many of us find it offensive. Unlike most other tribes, we generally don't make an Indian versus non-Indian distinction, but rather a Navajo versus non-Navajo distinction. When it comes to federal major crimes and Navajo Nation major crimes, the word Indian is more of a legal correct term. So I will frequently be using the word in today's presentation as the Navajo Nation has jurisdiction over both Navajos and non-Navajo Indians, meaning people who are members of other federally recognized tribes and other than the Navajo Nation. We lack criminal jurisdiction over non-Indians who are, of course, also non-Navajos. With that being said, I will turn to today's topic now, an introduction to the Major Crimes Unit of the Office of the Prosecutor within the Navajo Nation. My name is Ethan J. Arviso. I am Sidnajuni, Kiani, Vitatni, and Sayatskidni, and am also an enrolled member of the Navajo Nation. I'm also a licensed attorney for the state of New Mexico, and I am also licensed to practice law in the Navajo Nation. I grew up primarily in Crown Point, Navajo Nation, and graduated also from Crown Point High School. So go Eagles, everyone. I'm also a double Lobo. I completed my undergraduate degree at the University of New Mexico in Albuquerque, majoring in both history and sociology with a pre-law focus. I then attended the University of New Mexico School of Law and graduated in 2021. I became a licensed attorney in 2022 and became licensed to practice on the Navajo Nation that same year. Today, I am assisted off screen by my colleague, Kevin C. Barnett, Esquire, who will help me collect your questions and comments for me to provide and answer in response to after the presentation. I began working for the Office of the Prosecutor last June by starting training with district prosecutors within the Eastern Agency of the Navajo Nation, such as Mr. Michael S. Platero. He was one of the prosecutors that helped me and guided me along in those early years, or the early frame time. I then formally transferred to the Major Crimes Unit, MCU for short, in December. I became the team leader in January of this year as well. Now, here's some legal background to major crimes in Indian country. So, Now I'm going to provide some legal background to major crimes within Indian country, including the Navajo Nation. Indian country is a legal term defined at 18 U.S.C. Section 1151. It includes all lands within the exterior boundaries of Indian reservations, dependent Indian communities, and allotted lands, the rights to which have not been extinguished. Think of Eastern Agency for the Navajo Nation. Again, as I stated before, we are turning to heavy topics, and I would encourage those of you who would prefer not to hear about such things to stop listening now, if you have not already. Prior to European, including Spanish contact, we, the Navajo people, relied exclusively on our own methods of traditional dispute resolution. But especially as the United States started its what they call the manifest destiny expansion into the west and southwest of this continent, gradually English American justice concepts were thrust upon the Navajo Nation. In 1883, the U.S. Supreme Court heard a case involving a rural Lakota living on what was then called the Great Sioux Reservation, in what is now the state of Dakota, South Dakota. That man known in that case was Crow Dog, and he was federally prosecuted for killing another Indian on Indian land. The Supreme Court held that the United States lacked jurisdiction under the then existing federal law to prosecute an Indian on Indian crime on tribal lands. Therefore, Congress responded to this by passing the Major Crimes Act, which is now codified at 18 U.S.C. Section 1153, and gives the federal government criminal jurisdiction over major crimes perpetrated by Indians, including all those listed on the screen. The act has been revised from its original form to include those listed on the screen now. A year later, the U.S. Supreme Court upheld that act as a permissible exercise of Congress's trust relationship with Indian tribes in another case called U.S. v. Kagama. During the termination era, Congress enacted legislation that gave ultimately 6 states criminal jurisdiction over tribal lands and their state boundaries. Those states do not include any states in which Navajo Nation resides. They're listed on the slide here along the exempted tribes. This law is called Public Law 280. In 1968, a part of societal-wide efforts to respond to crime and also to attempt to rein in the U.S. Supreme Court's conduct in cases like Miranda v. Arizona and among others, the Congress, among its many legislative enactments, passed what is called the Indian Civil Rights Act. One might think this is great, providing Indian civil rights, but really it was in effect another attempt to control tribes and make their justice systems more akin to the systems provided in the U.S. Constitution and also in many state constitutions. In response, and out of concern that Arizona might, under Public Law 280, get criminal jurisdiction over all crimes on Navajo Nation's Arizona portion at least, the council crafted the Navajo Bill of Rights, which are summarized on the slide here, and you can also find them codified at 1 Navajo Nation Code sections 1 through 9. Another issue with the Indian Civil Rights Act, or ICRA for short, was that it constrained tribes' ability to sentence offenders to jail time and also limited the maximum sentence to 6 months for all crimes. That includes murder, rape, burglary, robbery, and any other crime you can think of, pretty much. 6 months maximum. This was eventually expanded to the default of 1 year, however. So currently, the Navajo Nation can only sentence offenders to a maximum of 1 year for all offenses. That does include the above mentioned crimes, which does include murder. In 2010, Congress passed the Tribal Law and Order Act, commonly referred to as TLOA, which would allow tribes that revise their laws to provide certain due process protections to sentence offenders to up to 3 years per offense for a total of 9 possible years if the person is sentenced consecutively for multiple offenses. The Navajo Nation has not enacted the ability to enhance the nation's sentencing authority. Currently, the maximum sentence for someone who murders another, including another person or even family members at this point, is only 1 year in jail, which is also the maximum sentence they can face for something like bribery, and bribing, say, a council delegate, a judge, or even the vice president or president. However, turning to another constraint of the Navajo Nation, in 1978, the Supreme Court decided the case Oliphant versus Suquamish Indian Tribe, in which it held that the tribes have been implicitly divested of their ability to prosecute non-Indians, meaning that my colleague sitting here with me, who is a non-Indian, which means he's not a member of a federally recognized tribe, nor is he eligible for such membership, cannot ever be prosecuted and jailed for violating Navajo law, nor can any other non-Indian as well. In 2013, Congress realized that Indians who were in romantic relationships with Indians were essentially able to avoid accountability for engaging in domestic violence perpetrated against Indians, and that tribes which should be able to prosecute such Indians. And for that reason, it updated the Violence Against Women Act to allow for such prosecution. In 2022, however, Congress again updated the Violence Against Women Act and removed the requirement that there be a romantic relationship between the perpetrator, such that non-Indians can be prosecuted by participating Indian tribes for certain covered crimes, which are now listed on the screen. The Navajo Nation has not enacted what is called Special Tribal Criminal Jurisdiction, STCJ, meaning that although it is legally possible under VAWA, the Violence Against Women's Act, for the nation to gain the ability to prosecute non-Indians, we are still only able to prosecute Indians, including non-Navajo Indians. Now I want to turn to how the Major Crimes Act works on the Navajo Nation today. We exist in 3 federal U.S. districts: the District of Arizona, the District of New Mexico, and the District of Utah, all of which have a U.S. presidentially appointed lead prosecutor called a U.S. attorney, who are essentially the chief prosecutors for those districts. Other states have multiple districts, but Utah, Arizona, and New Mexico all only have 1 district, each of which has its own U.S. attorney. There are also 5 FBI field offices that provide federal investigation services for Major Crimes Act cases. However, when there is a federal wildlife offense, the U.S. Fish and Wildlife Service would be the relevant law enforcement agency. But those 5 main FBI offices that we were mentioning earlier are located in Gallup, New Mexico, Flagstaff, Arizona, Monticello, Utah, Farmington, New Mexico, and lastly, Albuquerque, New Mexico. So, the United States has this jurisdiction to prosecute Indian perpetrated crimes on the entirety of the Navajo Nation's Indian country. This does not include, however, non-Indian allotments in the Eastern Agency, however. But what happens when it does not meet the high threshold necessary for federal prosecution to be initiated? The case is issued a declination letter by the relevant U.S. Attorney's Office indicating that they will not be pursuing federal charges. However, cases may never get to that stage for multiple reasons. The Major Crimes Unit that we are currently situated and have started tracks 3 types of declinations of federal involvement, which are not official and are only our way of describing federal involvement in these major crime cases. First is what we call a preliminary declination, where a Navajo criminal investigator calls an FBI agent and explains the facts on the ground, and the agent declines to come out, probably most often because the facts being conveyed to the agent do not reach a certain criteria. The second theory of declination that we have in the MCU unit is what we call an intermediate declination, where the case is referred to the FBI and the supervisory special agent for one of the 5 field offices I mentioned earlier, and they issue a letter that alleges the facts and do not warrant a launching of federal investigation, though. This is referred to as an administrative closure of a case. Third, within the MCU and our theory of declinations is what we have here. This is what we call final declinations. And that is the letter issued by the federal prosecutors, not the federal law enforcement, meaning the FBI, declining prosecution of cases. However, we'll talk more about these declination letters a little later. So how do cases get referred to the U.S. Attorney's Office for potential prosecution? Well, often a Navajo criminal investigator will start an investigation, and an FBI agent will later be brought in to contribute or review the CI's investigation. Or the FBI agent alone will be investigating the case from the start. One or both of these types of officers, FBI agent and Navajo criminal investigators, will then, and when they feel that the case is ready for referral, refer that case to the USAO for potential federal prosecution. Then either the case will eventually move forward to being federally prosecuted, or it will eventually be declined. There can be many additional steps between the referral and those actions, but that is pretty much the bottom line. Now we'll be moving to the foundations of the Major Crimes Unit. Chief Prosecutor Vernon L. Jackson Sr. is the current Navajo Nation Chief Prosecutor. He became the permanent Chief Prosecutor in June 2022 after having served as the acting delegated Chief Prosecutor beginning in July 2021. A former FBI agent and most previously the Crown Point District Prosecutor, Chief Jackson was keenly aware of the federally declined cases. He had a concern that these cases, through a variety of different reasons, were essentially being ignored by the Navajo Nation. See, after a case is federally declined, and unless it involves a non-Indian perpetrator, the only sovereign that can criminally prosecute it is the Navajo Nation. So, if after a case is federally declined, the Navajo Nation does not prosecute it, then that means no sovereign can prosecute. This includes the state of Arizona, the state of Utah, and the state of New Mexico. The attorneys generals of those states lack criminal jurisdiction over Indian perpetrated crimes on the Navajo Nation. However, Chief Jackson hired a law clerk in the summer of 2022, a law student, to begin a deep dive into these federally declined cases and to also try to provide some insight onto what these cases reflect about the state of public safety on the Navajo Nation, as well as its prosecutorial effectiveness. That law clerk spent about 8 weeks analyzing the data and worked with the chief prosecutor to draft a report that explained what the actual data shows, and more broadly, what were these roadblocks that were holding criminal offense what were the roadblocks that were not allowing the Navajo Nation to hold these criminal defendants accountable for the crimes. That report was issued in its first version to the 3 USAOs, also the relevant FBI offices, and several, and then later on, all of the council delegates for the Navajo Nation. This led to a renewed interest in revising Title 17. For reasons I will expand on soon, there was an effort to revise Title 17, which, except for traffic offenses, which are found in Title 14, is the Navajo Nation's main criminal code. That effort ultimately did not pass at the tail end of the 24th Navajo Nation Council, when the council hoped to pass a myriad of legislations, and in fact, almost none of which were able to be voted on fully by the time the deadline hit. But the final declinations report also served as a major contributing factor to the chief prosecutor creating the Major Crimes Unit, the unit that I and 4 others are currently working in. The first hired prosecutor was the law clerk, who co-wrote the final declinations report and started during his last year of law school. As the MCU has become fully staffed, the work has continued to focus on tracking cases, expanding analysis of the data, and working toward finishing a third and final version of the declination report, the conclusive report on final declinations, which we anticipate will be over 115 pages long in the few coming months. As the unit has worked to update the data, we have updated the graphs, data tables, and other analysis for use in the conclusive report. But here, for perhaps the first time publicly, we will be showing you some, but not all of the data. In total, there are 25 graphs and 5 pages of data in Word format only. We will be showing you some of the highlights of the data here and now. The first data table is a plain data of all cases that we are aware of that were federally declined between January 1st, 2016 and December 31st, 2023. This first graph, and please ignore the graph numbers as they reflect their position in the conclusive report's appendices, shows us which federal district USAOs issued letters for how many cases. The next graph shows us which tribal prosecutorial districts those offenses, as best as we can tell though, if we can even tell, the offenses allegedly occurred in. This graph shows us the stated reasons, or rarely the unstated reasons, for federally declining prosecution across the cases we reviewed. Finally, and perhaps most importantly, for you all to appreciate the types of crimes we are talking about, these 2 graphs show what types of crimes were declined. You can see the most commonly declined crime involves allegations of sexual assault or abuse, including non-contact offenses of children. This means that 1 out of every 3 letters, statistically speaking, involves allegations of sexual assault or abuse of detained children, which means I could pull 3 declination letters out of this stack, and statistically speaking, one of them would be a child sexual assault allegation case. The second most declined offense type involves physical assault allegations. And the third most, homicides, murders, and death investigations, with the fourth most being rapes of adults. The next graph breaks down offenses that have only been declined once or twice, or at most 4. These next 2 graphs show the alleged incident dates, meaning when the alleged conduct occurred and the frequency of incident dates in a given year. So as you'll see on the screen, on the y-axis, that is the enumeration of incidents, and on the x-axis is the year. So if you look at 1986, we can see 1 incident happened at that time. Similarly, with the last graph, again, on the y-axis is the number of times an incident occurred, and on the x-axis is the year those incidents occurred. So we can see here again in 2012 that we had probably 1 incident occur in that time. 2014, we had about 2 incidents. So why are these incident dates so important for these 2 types of crimes? Child sexual assault or abuse, and homicide and death investigations? Well, because quite a long time ago, likely decades ago, the Navajo Nation Council made the policy decision that the statute of limitations for all crimes should be 3 years from the date of the incident. So you may be thinking, are you telling me that there's a 3-year statute of limitations for murder and other major crimes? Yes, that is exactly what I am telling you, that there is only a 3-year statute of limitations for crimes like murder on the Navajo Nation. However, in 2017, the council changed its view on the statute of limitations, but only for certain offenses, including white-collar crime offenses and certain offenses related to interfering with court process, such as trying to bribe a juror or threatening a juror. The new statute of limitations for most of these non-violent, mostly white-collar crime offenses, you might ask, 10 years. That's 10 years not from when the offense occurred, however, such as when you bribed the juror, but 10 years from when it was discovered that you bribed the juror. So if it's not discovered for 9 years that you bribed a juror, then the office of the prosecutor would have 10 years from that date, which would be a total of 19 years from when the offense occurred to commence the prosecution. That legislation was CO-59-17 and was signed into law by President Russell Begay on November 6, 2017. That legislation, however, did not change the statute of limitations for any violent crimes. So, while the office of the prosecutor would have 10 years from the date it's discovered you bribed a juror, we would only have 3 years from the date of the juror's death if you murdered him to prosecute you for his murder or her murder. So to kind of clarify, we can use an example. Let's say I offer to sell this bracelet to my colleague who is in the room with me, and I tell him it's 100% Navajo made. But let's pretend it's actually foreign made, and I know it's foreign made, but I lie and tell him it's Navajo made. Well, that violates Section 344 of Title 17, known as misrepresentation of Navajo produced goods. And the office of the prosecutor would have 10 years from when it's discovered that I lied to prosecute me at that point. But if someone was murdered on the Navajo Nation instead, the office of the prosecutor would be able to prosecute that if it filed charges within 3 years of the victim's death. So that means if I confess 3 years and 1 day after killing someone, I could never be prosecuted on the Navajo Nation. And that is certainly an alarming reality that the Major Crimes Unit in particular has to be concerned with about, as after cases are federally declined. It's quite possible the Navajo Nation statute of limitations has run out when the federal prosecution is declined. Now, I would like to read you a passage from a 2011 Navajo Nation Supreme Court case where a Navajo man sued several persons and entities, including the Catholic Diocese of Gallup, New Mexico, alleging he was sexually abused by a priest in the mid-1980s when he was a young boy. However, but for civil cases, essentially what the rule is that one has to file within 2 years of their injury. Well, this individual explained that he had only recently come to understand the sexual abuse that he had suffered and that he had only just recently appreciated that he had actually been injured. Navajo Nation Supreme Court reversed the district court's dismissal, saying, among other points, that, quote, our courts have a duty in parens parenti to ensure allegations of harm to our children are fully heard and not dismissed on mere technicalities, end quote. While this case is not related to a civil lawsuit while this case is related to a civil lawsuit and not a criminal prosecution, I think the principle holds true in the criminal context of seeking justice for our children still. Our murdered relatives and those who our murdered relatives and those of us who have been victims of sexual abuse. Now I'd like to switch gears a little bit and move to a without consent definition and turn now to a notable success of the Major Crimes Unit and the Office of the Prosecutor that has recently had. In working to change our criminal code to better allow for justice for those who are sexually violated, and this is especially relevant during what we are currently in now, the Sexual Assault Awareness Month. Staff within the Major Crimes Unit contributed to revising of the Navajo Nation's sexual assault statute, specifically by providing updated definitions to what without consent means. Without consent is defined at section 433, subsection Q. And originally, the main ways of proving that a sexual act, meaning intercourse, or a sexual contact, meaning sexual touching without consent, was by needing to prove that the perpetrator of a rape or sexual assault used force against the victim or threatened to use force against that victim, or a variety of potential reasons, such as being incapacitated. These previous main definitions thus required violence to be used against the victim, or the victim to be, say, asleep or unconscious, in order for the violation of their sexual or bodily autonomy to be legally a rape under the Navajo Nation law. So staff within the unit contributed to drafting 2 new definitions. One, an affirmative consent definition, and the other, a negative consent definition, that were ultimately adopted into the Victims' Rights Act of 2023. So, negative consent means that the victim stated or communicated that they did not wish to engage in a sexual act or sexual contact before it occurred. Essentially, no means no. But that is not as effective as a definition as it might seem, because no means no requires the victim to specifically refuse consent before they are sexually violated. However, affirmative consent operates under the concept that you need to consent to start engaging in sexual behavior, and that consent must be present throughout the entirety of the sexual behavior and can be withdrawn at any moment. Thus, affirmative consent means this: the absence of a no does not mean a yes. Unlike negative consent, the victim does not need to say or communicate no before any sexual violation becomes without consent, and thus a sexual assault. Think of it this way. If 2 people are walking down the street past each other, and the perpetrator grabs a victim in a sexual manner as they pass each other, The negative consent, which is a no means no definition, would not call that a sexual assault because the victim did not explicitly say, "No, you may not touch me in a sexual manner," before the perpetrator did just that. Of course, we in Navajo society, and perhaps every society, do not go around refusing consent to sexual acts of sexual contact with every person we walk by or run into. Affirmative consent in that previous example I just provided would say that nothing about the victim's behavior indicated their willingness to be touched in a sexual manner, and for that reason, there is no consent, and the perpetrator's conduct is a sexual assault. Now, I want to turn to the actual Major Crimes Unit staff. So we've discussed a lot of the concerning challenges the Navajo Nation is facing regarding major crimes and some of the efforts to address issues in Navajo law. However, who are the staff members in the Major Crimes Unit? Well, we have already introduced me, Ethan J. Arviso, who is the current team leader of the unit. And I will be covering the districts of Tohadjale, Alamo, Crown Point, Pueblo Pintado, Shiprock, and Aneth. With me is Kevin C. Barnett, Esquire, who is assisting me in organizing your questions and comments today, and is one of the other prosecutors for the Major Crimes Unit. He has an honors bachelor's degree in history and psychology with certificates in German and American Indian Studies from the University of Wisconsin-Madison after graduating from Center Grove High School in Greenwood, Indiana. He has previously worked as a child protective services social worker in the Lac du Flambeau tribe in northern Wisconsin. He earned his law degree from the University of Kansas School of Law with a tribal lawyer certificate. He worked as a legislative intern for the 24th Council in summer 2021 and worked as a law clerk for the Navajo Nation Chief Prosecutor in summer 2022. He is licensed in the state of New Mexico as an attorney and has also passed the August 2023 Navajo Nation Bar exam and is awaiting to be sworn into the Navajo Nation Bar. Attorney Barnett will eventually be covering the districts of Dilcon, Tuba City, and Kayenta. He joined the MCU in November 2022 as one of the first 2 employees of the unit. Along with Kevin and myself, we have Sierra D. Moore, who earned an undergraduate degree from the University of New Mexico in psychology and criminology. She later became a Sun Devil and earned her law degree from the Sandra Day O'Connor College of Law and at the Arizona State University, with also an Indian law certificate. She graduated from St. Michael's Indian School for high school. She has also worked as a law fellow for ASU Law's Indian Law Legal Clinic and joined the MCU in December 2023. She will eventually be covering the districts of Window Chinle, Jislajin, and Rama. She passed the August 2023 Navajo Bar exam and is also waiting to be sworn into the Navajo Nation Bar. Tijuana F. Jim Faber is the unit's senior legal secretary, a graduate of Tohatchee High School and the legal advocate program at Navajo Technical University, along with a degree from Grand Canyon University in criminal justice. She provides logistical support and assistance in collecting police reports, federal investigative materials, and all around help in keeping the Major Crimes Unit organized. She joined the unit in November 2022 as also one of the first 2 employees for the Major Crimes Unit. And to round off the Major Crimes Unit, we have Mr. Delbert J. Largo. He is the unit's senior investigator. Also a graduate from Tohatchee High School, Mr. Largo has extensive experience in corrections and probation-related fields and joined the unit in January of this year. Mr. Largo has also attended the Southwest Indian Polytechnical Institute, or commonly known as SIPI, also within Albuquerque, New Mexico. So what are the functions of the Major Crimes Unit then? We've heard a lot about who works in the Major Crimes Unit, but what exactly do we do? Well, we are still in the early phase and we are working toward establishing full operational capacity at the moment. However, here are some key functions that we do. We are the conduit to receive, process, and analyze federal declination letters, this stack, of which 463 have been issued between January 1st, 2016 to this week, representing 511 declined suspects. In fact, as we were getting ready for this presentation, we actually did receive one more declination letter. So I think we need to update that now to say 464, also representing 512 suspects at the moment now. So when the Navajo Nation receives a declination letter, we catalog it, save it in various ways into our database, and then we assign it a color code to help us keep track of what the case calls for. The color code tracks a variety of potential aspects of each case. We then acquire federal investigative material and Navajo Nation investigative material for review and consideration of prosecuting selected federally declined cases. As we discussed today, we cannot prosecute all cases primarily because of the statute of limitations, which is more favorable toward white-collar crime cases than it is violent cases such as murder. Sometimes also a case is federally declined because the suspect is now deceased. Other than federally declined cases, we also handle all extradition matters. Extradition being when a state or other tribal nation requests that we arrest and transfer a person into their custody because that jurisdiction has pending criminal charges or are seeking to revoke that person's probation. We also take referred cases. Those are cases that are particularly complex or challenging, and those involving sensitive topics, such as criminal conduct by persons in high government offices or positions of comparable power. Furthermore, we are also tracking habitual domestic assault offenders for potential referral for federal prosecution under a law codified at 18 U.S.C. Section 117, known as domestic assault by an habitual offender in Indian country. So essentially, we are here to handle the difficult cases, ones that involve the most unpleasant subjects. We are not here to prosecute public intoxication, bootlegging, disorderly conduct, and some similar crimes on the Navajo Nation. Oftentimes, I have heard people express surprise that the Navajo Nation can prosecute the serious offenses, the major offenses, that they thought only the federal government could provide justice for Navajo victims of on-reservation crimes. What happens when the federal government declines to prosecute? Then that leaves us, the Major Crimes Unit, and within the Office of the Prosecutor, the only entity that can prosecute and provide justice. And I would say also that even though it does appear that 1 year maximum that we can sentence a person does not seem great when it does refer to a major crime, I would end my presentation today by saying that our Navajo justice is better than no justice, and 1 year for murder is better than no time for murder at all. So with that, thank you everyone for tuning in today and learning about the Major Crimes Unit for this Lunch and Learn with the Navajo Nation Department of Justice. And it does appear that we do have a few minutes to answer some questions. And as I stated earlier, my colleague was tracking these questions. All right, we have Mr. Gerald Chavez. His question was curious about the Treaty of 1868 and its relevance to this process. Well, here's our answer. I'm sorry, what is that? Okay, so the Major Crimes Act, Major Crimes Act applies despite the Treaty of 1868. We appreciate that question, Mr. Chavez. We got another question from A. James. Is information going to be made public from graphs and the report? The answer is yes. Eventually it will be, and we can elaborate a little bit more further, but at the moment the report is not complete. It does need to go through some final revisions as well. As we stated, the report's looking like it's going to be well north of 117 pages at the moment. And as we stated before, we're still getting data day in and day out, and trying to maintain and keep up to date on the actual report. So backtracking to the question, yes, this information will become public, however, and it'll be in the future and not so near at the moment. We have another question here from a Miss Nishi. She says, great presentation. Thank you. For extradition requests, who is the main contact? Well, the main contact for the Navajo Nation Office of the Prosecutor for extradition matters would be the Chief Prosecutor, who will refer that, once he does get the referral, he'll then refer it to us, to Major Crimes Unit. And once that occurs, and you do have a person that you do want to extradite, we do have a memo compiled together by the Chief Prosecutor that lays out the Navajo Nation statutes and the process to actually extraditing a person. It does require quite a few documents and information that can provide, so that we can provide that, A, this person is indeed the Indian who committed the offense in the state that they are requesting, and B, that they are going to receive a fair trial in that state for which they are requesting the extradition. Another question from Mr. Gerald Chavez again. Asked about Indian Arts and Crafts Act of 1990. The answer is yes. The federal government also can prosecute arts and crafts crimes, and as can the Navajo Nation. There hasn't been much enforcement of Indian arts and crafts, however. We do have one clarifying point to our presentation. The declinations in the pile date back to January 1st, 2016, and the most recent was received yesterday. The graph showed earlier only covered cases declined between January 1st, 2016 and December 31st, 2023. So they don't include the letter that we received yesterday, April 11th, 2024. However, it is still a large stack, as you have seen. And we do thank the Office of the Prosecutor for going through all of these and making the conclusive report as well. Well, again, we do appreciate all of you for submitting your questions today and sitting in today for the Navajo Nation Department of Justice's. One moment here. I apologize, Attorney General. I think you might be muted.
Oh, thank you. Thank you so much for your presentation, Ethan. That was really great. I assume Kevin introduced himself as well.
Well, not formally on the camera.
Yeah, he should.
Yeah. I think the crowd would appreciate meeting this one.
I want to see more than a hand. Just kidding.
Hello, I'm Kevin C. Barnett. I am Beish Bachahi, German Iron Metal Hat Clan, born for Dagahalchi, curly red mustache, Irish clan. Just was helping Mr. Aviso off camera today. Thank you.
Great. Thanks so much, Kevin. And as Ethan mentioned earlier, Kevin played a significant role in compiling the data on the declination report that the Office of the Prosecutor has published. And I believe that report is available on the Office of the Prosecutor's page. Is that correct? Do we have that available online, or can folks request that directly from the Office of the
Um,
Prosecutor?
I don't think it's publicly available on the website right now. And not yet, at least. And like I did say that we are still trying to finalize the final report.
Okay.
I'm sure that the final report, once it is finished, will be posted on the Office of the Prosecutor website.
Great. That's wonderful. And the Chief Prosecutor and the Office of the Prosecutor, the Office of the Public Defender, Law and Order Committee are all in the process of compiling amendments to the Navajo Nation Code, specifically relating to the criminal code, both in Title 17 and in Title 14. Title 14 covers fish and wildlife, natural resource related crimes. And so that there's actually supposed to be a work session on that on May 3rd. So if folks are interested, when I was Attorney General previously, we made those amendments to the statute of limitations in the white collar crime provisions, extending those to 10 years to allow greater opportunity for prosecution of those crimes. How that came about was we had a very significant white collar crime occur. And at the time, our statute of limitations were either coterminous, or so they occurred at the same time as a federal statute of limitation, or they occurred earlier, which was very problematic. You heard about the high declination rate by the federal prosecutors. And so if they were holding the evidence and still deciding whether they were going to prosecute a case, and they made that decision at the last minute, there really wasn't, assuming that there was communication, and there's not always communication from the federal prosecutors to the nation. That's something that has been a challenge. When they have let us know that they're declining to prosecute a case, at the time it was difficult to actually do that, because we would either be beyond the statute of limitation under Navajo law and unable to prosecute that case, or we would have a very short period of time. And with white collar crime cases in particular, they tend to be very document intensive. And take a lot of time to put together in terms of the case. So we were experiencing a challenging situation where we might not have been able to prosecute really important cases, high dollar theft amount cases. And so we were able to pass just the focused white collar crime amendments. And then that kicked off a larger process where we felt like some of these things, like homicide or sex crimes against children, should not have any statute of limitations. And so we had an extensive effort, lots of consultation with lots of members of the nation's public safety partners, and we came up with model amendments. And part of the challenge was that the Navajo Nation Code is not regularly updated by legislative council. That's a really important role, and unfortunately it just, there's a significant lag time. So it was difficult to piece together what the current version, what the state of the law was. And so there were some hiccups in that process. But we did present proposed amendments. Those never really gained traction because we could never get agreement with legislative council on what the actual current state of the law was. And this to get the amendments in, you kind of need to know what the law says right now. So that was very unfortunate that we were not able to move those amendments forward at that time. But that work continued into the Nez administration. And then we have picked that up. Of course, that's high priority for this administration, as well as to get those changes through. And it is also a high priority for the Law and Order Committee. And so I'm very hopeful that we're close to moving forward some changes. And we've been able, in this round of compilation of amendments, the chief prosecutor has been very successful in working with the public defender. There was legislation during the Nez administration to pass some comprehensive amendments, but there wasn't sort of a shared view between the prosecutor's office and the public defender as to what those amendments should be. And so that legislation wasn't successful. So we're hoping that by having a shared view by the public defender as well as the chief prosecutor on what the amendments should be, that we can have success in passing these long overdue changes. I mean, so Ethan mentioned the Victims' Rights Act amendments, and those were super, super important because I think, we basically, the victims' rights movement that happened in the United States in the 1980s never happened at Navajo Nation until those amendments went through. And unfortunately, our laws are just greatly behind the times and need a lot of updating. So I'm very hopeful that these amendments will move forward. And so stay tuned, everyone. If you're interested in that, please tune in for the work session. That's going to be in Albuquerque. You can watch the council's website to see if information changes or as information is released about where it's going to be, what time, and all of that. So, but just very thankful for the hard work that Ethan and Kevin are doing. I didn't introduce myself. I just kind of jumped in. Ethan let you know who I was, but I'm the Attorney General for the Navajo Nation. I served as the nation's 11th Attorney General under President Russell Begay. And then, of course, I serve now under President Boo Nygren. And it's an honor to be in this role, and especially to be able to do this a second time and have the experience of the previous term. And that's part of why the amendments are so important to me, is having the understanding of the great need that we have for those from my last service in this role, and then also understanding that it takes some time for everyone to kind of get on the same page. And so I'm really happy that this has been one of the top priorities for the chief prosecutor, and it feels like we're very close. And so very, very hopeful about that. But just to introduce my clans, Bipatwani Nishle, Nakai Bashishchi, Sitnajini Dashache, Aronakai Dashanella, Kintana Kehashte, East Canyon Diablo Ditnasha. And I'm actually mostly in Window Rock in order to be able to serve in this capacity in the best way possible. And so, again, thank you, Ethan and Kevin and everyone in the Major Crimes Unit. It's so exciting to have a Major Crimes Unit that is new under this administration. I'm very thankful for the great leadership of the Chief Prosecutor and moving that forward, and just keeping the team together. And he's done a lot of work to build morale, and so I'm really thankful for his wonderful leadership and for putting together this lineup from the Office of the Prosecutor for the month of April. So be sure to stay tuned. Again, this is a series that the Office of the Prosecutor is putting together for the month of April. So fitting with it being Sexual Assault Awareness Month. And so please tune in next Friday at noon again, and everyone have a great weekend.